Hey, welcome to Employment Hour in 30. Once again, if you're just joining us for the first time, this is Employment Hour in 30. We discuss workplace rights, your workplace, where you spend most of your life until you're probably 65, like the rest of us. If you're joining us for a second time or beyond, welcome back to the show. Good to have you here. Anytime you need to get a hold of Lior, a member of the team, 1-855-821-5900, or help, or employmenthourtv.ca, rather, or help at employmentlawyer.ca through email. We'll reference some emails later on the show. We are going to talk about Lior phone calls from our live radio show. We'll get to that. Your long-term disability rights and coming back from mat leave. That's always the elephant in the room when it comes to employers and employees and those that have been on mat leave. A lot of stuff to get through. We'll talk about the severance pay calculator as well. But first, I digress. We get to the week that was, something that's been happening for you in the office. How are you, pal?
You know, other than kind of being recognized on the street and told, hey,
Hollywood.
But, you know, I've been recognized, but not to say, hey, you're doing a good job. They're telling me I've used the severance calculator, actually, and I've used it, and now I know what I'm owed, which is great, which means the fact that we're here, the message is getting across. We're getting our message across. We're informing people about their rights. So if you haven't watched our show before, you don't know what this Employment Hour in 30 show is about, it's about you, your workplace right, your job, the things that you need to know about if you have a problem at work. We're going to solve those problems. We're going to talk about things that you need to know. Believe me, those are important topics. Things come up in the work, John. They have for you, they have for me. Sometimes things don't go perfect, and you need to know what your rights are, how to solve those problems. So stay tuned for the next 30 minutes. We're going to be talking about many things that you need to know. And of course, if you don't get your answer here on the show today, call me at the office, email me. We can talk about your specific situation. And the week there was, John, a situation that came across my desk where I think our viewers will find something interesting to learn from. I spoke with a gentleman who was working as a soccer coach in a large soccer club. He was coaching some very senior teams and had a good job, well paying. You know, those jobs are rare. They're few and far between. It's not like there's 1,000 soccer job coaches out there. Well, unfortunately, he had to go off on a medical leave for some health reasons. He was off for a few months, and his employer did the reasonable thing. They had to bring in another coach while he was off. Still needs to, the teams need to be coached. They can't be without one. But when he came back, his old job wasn't available for him. The only thing that was available for him is he could coach more junior members of the club, lesser teams, and not even on a full-time basis. And they said, well, keep your salary the same because it's not your fault that you had a medical condition, but it's going to be a much lesser position.
Right.
And he was obviously concerned about that, and he called me. Now, here's the thing, John. Clearly, the company here, the employer, was acting in good faith. They were doing nothing wrong from an ethical standpoint. They had to fill in a position, they did, and now they don't have the same role for this person.
Sure.
But despite the fact that the company is acting in good faith, it does not change the legal principle, and that is that you cannot change someone's terms of employment. This was a demotion. Any way you look at it, this was a lesser position. Even though he was not making less money, it was a demotion. And what does that mean? That means it's potentially now a constructive dismissal. He has the right and the ability to treat that as a constructive dismissal and leave with a severance. Now, I wanted to bring this up here for two reasons. Number one is the changes that you may experience at work may not be because the employer is doing something wrong or because they're bad. They may have a legitimate reason. But despite the fact that the company has a legitimate reason, you still may be able to treat that as a constructive dismissal. And the second reason I wanted to bring this story up is because of the fact that even though your pay may not decrease, you could still be demoted. It could still be a constructive dismissal, even if your pay is the same.
A lot of people would say, hey, you know, it's not too bad. I guess he's still coaching. He's still making the same money. But I guess it would be a case of, you know, in the future, if another head coaching job came up, someone might say, well, you were the junior guy.
You're more junior.
You weren't the main guy.
Yeah, it's going to hurt his career prospects. It's going to hurt his ability to move on up and get another position. And again, it's a lesser position. So anytime you've been demoted, even if the compensation is the same, you potentially are in a situation where you can treat it as a constructive dismissal. That said, I don't want anyone quitting. I don't want anyone throwing their bag down and saying, I'm out of here, without talking to me first.
Live Employment Hour radio show. You'll want to go to employmenthourtv.ca to find a station or at least listen to the podcast of previous shows that we've been doing for about 6.5 years. We get a lot of calls on those shows every week. We'd like to take, or at least cherry pick a few of them, play them back in this show and get some perspective.
Just had a recent issue with a manager in the workplace. He asked me to do a specific job, and I did it, but he criticized it not liking it and wanted me to go out again and do it. Many things were said and many words were exchanged. I may not be allowed to go back to work. I'm just wondering, can they say, no, you can't come back, just based on an incident?
How long have you worked there?
It'll be 2 years. I'm a receptionist, customer service. I'm 34.
A little uncomfortable, right?
Very comfortable situation. So this raises this concept of termination for cause. So clearly she did something wrong. If she got into an argument, maybe she said something she shouldn't have said, that's not a good thing. You shouldn't be doing that. You know, you should always be able to control your temper as best as possible. But that's not the end of the analysis. The fact that she may have done something wrong, the fact that there was this one incident when she stepped over the line, does not mean that she could be fired for cause. Not only that, in fact, a termination for cause can almost never happen if it's one isolated incident. Almost never. So the bottom line is, even if she did something wrong and they decide not to have her come back to work, that would be, in the eyes of the law, a termination without cause. You cannot usually be fired for cause for one incident. Even a few incidents is usually not enough. So what does this mean for her? It means she is owed severance if she is let go. It's a without cause termination. So what I've done is I've taken her information, I've plugged that into the severancepaycalculator.com website, just to give everyone an idea of what that would look like. So she's a receptionist, been there for 2 years, 34 years of age. So someone in her situation would be owed right around 3 months' pay. So that's the key. Even though she's in a junior position, she's not old, she's only been there for 2 years, she's still going to be owed 3 months' pay. Even though the fact she made a mistake, John, doesn't deprive her of that. So there's an important lesson there for all our viewers.
The employer has to build up a case over time. They can't just do one incident and let you go. That's not going to work, right?
The appropriate thing if she does something wrong is to give her a warning.
Right.
Say, you know, this behavior is not acceptable. If the problem persists and she does it again and again, well, at that point, the company may be able to say, well, there's nothing else we can do. We can let her go for cause. But to kind of jump from zero to a termination for cause, you can't do that, even if you did something wrong.
Another good resource for you anytime when the show is on the air or otherwise, terminationquestions.com. You simply ask your question for Lior or his team in there. There's a good chance your question has been asked and answered in depth. If not, leave it there. It will be answered very promptly. I want to read one to you, Lior, and get your feedback on it. Again, from terminationquestions.com. Says, I've been working for a company for 15 years. Just the other week, they said I will be temporarily laid off, and a co-worker will be covering my job. I'm 56 and worried that I might not be called back, even though I have a good work record. Should I just go with it in case they do call me back?
Well, temporary layoff, this is an important topic, and we've touched on this before on the show a number of times. So let's be very clear in understanding what a temporary layoff actually is. A temporary layoff is a termination. So even though the word temporary there suggests, well, I'm not being let go, just kind of my employment is suspended for a period of time. Well, no. The law says that a termination that temporary layoff is a termination. Your employer does not have a right to lay you off temporarily. So if you are laid off temporarily, you can treat your employment as being terminated and get your severance now, regardless of whether the company wants to call you back. Now, the question for this person that he's asking is, should I wait? Well, it's a personal decision. If you want to have your job, then I guess you can wait and see what happens. The problem with that, number one, is they may not call you back. Right. You may be sitting at home with no income for months and months and having a hard time supporting your family. Problem number one. But problem number two is, if they do call you back and you go back to work, you've now given them the right to do it again. You've given them the right to lay you off again and again and again, and the next time they lay you off, you won't be able to do anything about it. So because of that, my advice usually with a temporary layoff situation is, you're better off treating it as a termination. This person's been there for 15 years. He could be owed 14, 16, even 18 months of pay. Wow. So isn't it potentially better to take that severance, move on to a different job, rather than put yourself in that situation where you have no income, you've given the company the right to lay you off again whenever it wants? Not a good situation to be in. So for our viewers out there, if you've been laid off temporarily, you want to reach out. You want to give me a call or email. We want to talk at that point about termination and getting your severance.
There is some pretty severe boundaries when it comes to temporary layoffs that an employer can have. Is it like 13 weeks within 20? It's a lot. It's a lot, right, when it comes to how much they can lay you off in a year.
Right. So your employer may actually keep you on for months and months. It could be potentially 8 months in a span of a year if they continue your benefits. But again, despite that idea, the law still says, and common law says, that it's a termination on day one. The first day they suspend your employment, the first day they put you on a layoff, temporary layoff, you can treat that as a termination. You don't have to, but you have that right, and I say it's better to do that.
Again, employmenthourtv.ca to find where you can listen to one of our radio shows on podcast or otherwise. Going to get to another call, and we'll play that for you, and I know you want to talk about it, Lior.
I work for a small company. I've been employed for 23 years. We were under the assumption that we were getting severance, and then her accountant told her that the Ministry of Labor, because we are a small company of less than 50 employees, and she doesn't have a payroll of at least $2.5 million, that we don't qualify for severance.
Yeah.
That whole 2.5 million thing, that gets mixed up.
Oh God, John, it's this whole idea of the 2.5 million, the small payroll, is one of the main reasons why all these years ago you and I started doing this, the radio show actually,
right.
and of course this TV show. There's so many misconceptions. So let's be very clear, okay? I was kind of shaking my head when I was listening to this message here. Let's be clear. The size of the payroll doesn't matter. It does not matter. You get severance, big company or small company. Now, the size of the payroll may matter to your minimum entitlements. Your minimum entitlements may depend on the company's payroll size. But your full entitlements, what we call your common law entitlements, in other words, the only thing that really matters, has nothing to do with the size of the payroll. Big company with 2 employees or huge company with 2,000 employees have to pay the same severance. It's based on your age, position, and length of employment. The problem employers have, and I'll give credit to employers that want to do the right thing, is they'll call the Ministry of Labor, as it looks like this employer did, and they'll get the wrong information, because the Ministry of Labor can only advise with respect to minimum entitlements. Again, not telling you that that's only a small portion of what you're actually owed. So bottom line is, that information that this employee was provided is wrong. So what should they do? Well, again, we said this before a few minutes ago. Go to severancepaycalculator.com. Let's put that information actually on the severancepaycalculator.com site and see what this person is owed. So in a professional role, 23 years of service, I picked an age, 59, just as an example. They were given no severance because, again, we have a small payroll, no severance. Well, in fact, they're owed 2 years of pay, Johnny. 2 years of pay. Crazy. Because, again, the size of the payroll doesn't matter. So this is a real case. This is a call from our radio show. So please don't let that happen to you. Don't get that wrong information. Go to severancepaycalculator.com. Call me. Call another employment lawyer if you have to. No problem. But please don't believe any of these misconceptions.
That number, by the way, to reach out anytime, 1-855-821-5900. And we did this already. I mentioned it. Another resource, terminationquestions.com. I want to read one more to you before we take a break. Well, I want to get through this first. It says, I'm about to return to work after a year off on a maternity leave. I was just told that there was reorganization and my position is no longer available. They don't have an equivalent position either. What are my rights? I've been there for 4 years.
Yeah. So the first thing, of course, we want to remember is that your employer does have to take you back after a maternity leave as long as it's possible. I mean, in some situations, it's physically impossible. We shut down the department, we closed the office. Well, there's no role. So my first question to her would be, how sure are we that there really is no role there? Or are they saying that because they don't want to bring you back? Are they saying that because they would rather keep your replacement? Yeah, because if that's what they do, that's illegal. They can't do that. If, in fact, it's a legitimate situation where there's no role, they've tried to find a place, there isn't, they've gone through some changes, restructuring, it's legitimate, has nothing to do with her maternity leave. If that is the case, then it's only a matter of severance. At that point, it becomes a regular termination, and they would owe her severance based on her age, position, and length of employment. On the other hand, if it even has something to do with her maternity leave, even part of the reason that she's not being hired back is the maternity leave, that's illegal. It becomes a human rights violation. It becomes a breach of the Employment Standards Act. It's illegal. So is it a legitimate restructuring or is it not?
Right.
If it is, it's just about the severance. Otherwise, it's human rights as well.
Coming up, we'll get to more detail about the severance pay calculator and how to react when your performance is questioned. Stick around for that. 1-855-821-5900 to reach out. Lots more Employment Hour 30 is on the way.
Lost your job? Employment law myth number 7.
Involving an employment lawyer is expensive.
Fact. In most cases, fees are nominal, and the employer will ultimately cover the fees. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. SeverancePayCalculator.com. Accurate, anonymous, and free. SeverancePayCalculator.com. Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact, over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first.
And welcome back to Employment Hour in 30. If you want to reach out anytime to get a hold of Lior, 1-855-821-5900. There's also employmenthourtv.ca as well. We've touched on it. We've dipped into it a little bit in the first segment of the show. I want to get back into this. That is severancepaycalculator.com. Love this tool.
Yeah, so people may have heard us in the first segment talking about the severancepaycalculator.com website. What is it? What does it do? Why should you care? Well, it's a tool that allows anyone to find out in seconds, John, how much severance you're actually owed, the real amount, not your minimum amounts, not the information you're going to get from the Ministry of Labor, again, which is only your minimum amounts, your full entitlements. You go to severancepaycalculator.com, again, severancepaycalculator.com, and when you're there, you're going to answer 3 simple questions: your age, your position, and the length of your employment. That's it, not your name, not the company's name. And when you do that, you're going to find out how much severance you're owed. What is your worth in the eyes of the law? Whether that's 6 months pay, 24 months pay, or anything else. It's free, it's anonymous, it's easy to use, and it's the first place you go to. If you walked out of that meeting where they told you today is your last day, sorry, we're restructuring, and we've offered you 3 months severance. Is it good? Is it bad? Is it terrible? severancepaycalculator.com. And of course, even if you haven't lost your job but you're just curious, the very first place you go to.
We can sit here, we can talk about it, or we'll take it for a spin and run a scenario through it and see how it works. Right here, I was working in a pretty good sales job for 9 years, making $80,000 per year. 1 week before I was to get my annual bonus, I was let go. They said they're, quote unquote, going in a new direction. They handed me a check for 18 weeks' pay. Was that enough severance?
Well, first of all, from the sounds of it, it seems like a legal termination in terms of the reason. Yeah. Because, yeah, if they're going a different direction, the company is allowed to make a decision. We may not agree with it. We may think I'm better employed than the person you're keeping. But despite that, they're allowed to make that decision. They're allowed to let you go as long as severance is paid. So that's the question. After 9 years, is 18 weeks paid, 2 weeks per year, is that enough? You're shaking your head. You know you and I have been doing this for many years together. So it's not even close. But rather than me just tell you, let me show you. Let's talk about the severancepaycalculator.com website. And here's what it shows us. We input this information in a sales role, 9 years of service. I picked an age there. He was offered 18 weeks pay, 2 weeks per year. Well, what should it have been, John? 9 to 12 months. Yep. 9 to 12 months pay. So that is a difference with this salary of somewhere between $32,000 and $52,000. So that's why the severance calculator is so important. That's why it's there. That's why it's the first place you go to, because if not, you'll think, oh, 2 weeks per year. My Uncle Bob got 2 weeks per year when he lost his job last year. It's got to be good. Yeah. No, it's not good. severancepaycalculator.com.
And employmenthourtv.ca. It says TV, but there you can find a resource to find our radio shows, either on podcast or on AM radio as well. Take phone calls from the show like we did in the first segment. I'll throw another one up there, Lior, and get you to comment on that as well.
I started working for this company. The contract they presented me was a 6-month contract. I would consider this to be middle management. The 6-month portion of the contract expired, and now they're coming up with false accusations, performance issues. I'm trying to work with them in terms of trying to correct whatever issues that they're talking about. I have a pretty good feeling that they're going to let me go.
Yeah, and very common situation. And what I always say is very simple: is if they're raising performance issues, if they're right, if you agree with them, then tell them that. Do your best to improve. Tell them what you're going to be doing to improve. But if you don't agree with it, if you think that the performance reasons are bogus, or the issues are bogus, or they're making things up, or it's not really my fault, I was working part of a team, whatever it is, say so.
In writing.
Say so in writing. Always say so in writing. Let them know why you disagree. And why do you want to do that? Because if you don't, if you just remain silent, that is exactly the same as saying, I accept, I agree. If you don't agree, don't agree. And if you do that, if you put your position in writing, you're going to make it that much more difficult to let you go for cause down the road. So the best thing you could do is to respond. The worst thing you can do is remain silent. And remember, even if there are performance reasons, even if he did something where his job performance was not what it should be, it does not mean he can be let go for cause. It's very difficult to let someone go for cause. It's that much more difficult to let someone go for cause for performance reasons. The company essentially would have to show that the employee is going out of his or her way to do a bad job. And if that's not you, if you're not going out of your way, you're doing your best, you may not be meeting all the targets, it does not mean you could be let go for cause. If you are let go, you're going to get your full severance.
We are going to deal with your long-term disability rights after we take a short break. To contact Lior, 1-855-821-5900 or help at employmentlawyer.ca. Lots more Employment Hour in 30 is on the way. Stick around.
Lost your job? Employment law myth number 9.
I can just call the labor board instead of a lawyer.
Fact: the labor board cannot help an employee get their full entitlements. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. SeverancePayCalculator.com. Accurate, anonymous, and free. SeverancePayCalculator.com. Lost your job? Employment law myth number 7.
Involving an employment lawyer is expensive.
Fact: in most cases, fees are nominal, and the employer will ultimately cover the fees. Always go to employmentlawyer.ca and check with the employment lawyer first.
Hey, welcome back to Employment Hour in 30, and all of a sudden there were 3. We are back here. Good to have you along. If you just joined us for the first time, Employment Hour in 30, we talk about employment law. We also kind of dabble in disability and injury law as well. That is why your partner, Tumarkin, is here. Canada's #1 and only TV show about injury law, debunking myths, educating people on disability and injury law. That is why you're here. How you doing?
I'm good, John. How are you?
You're looking good. You're looking good. You're used to TV now. Now you're here with us, invading our space.
Mr. Celebrity here.
Mr. Celebrity. 1-833
One of us
in your
has to
corner,
be.
by the way. Want to mention that 1-833 in your corner moving forward to get a
Yes.
hold of you and your show as well.
That's right.
Now, I did mention if you go to employmenthourtv.ca, we do get a ton of phone calls on our radio shows. You guys both have radio shows. But on Lior's show, it's not only about employment. Sometimes people call in because there's a lot of cross-pollination between what you guys do. That is why you do both things at that firm. So some phone calls deal with both employment end of it and the disability side of it as well. So I want to play back a call from the radio show, and I know you both want to comment on it.
I've been on long-term disability for stress and anxiety and currently in therapy. Now, the insurance company, they want me to go back to work by a specific date. I'm not ready, and my therapist says I'm not ready. Do I have to go back? And the bigger question is, will I be fired if I say no, that I don't want to?
There you go. You got to go back.
So let me start with the analysis before we turn it to Savannah and talk about all options that this person has. So first of all, it's very simple. Even if your insurance company is saying you can't work, as long as your doctor is saying that you're not able to work, it doesn't matter what the insurance company says, and your employer can't say, well, wait a second, we'll believe the insurance company, we won't believe the doctor. If your doctor says you can't work, give a note to your employer. They can't punish you, they can't threaten you, they can't make you quit, they can't fire you in any way. If they do, I want you to call me. They have to allow you the time off as long as your doctor supports you. So that's easy with respect to the employer. Where it gets more interesting is, wait a second, if he can't work, why is the insurance company cutting him off to begin with? Which is really why we want to have Sivan give us some perspective as to why that would happen and what he could do about it.
Well, so the solution really is to stand up to the insurance company. And one thing that people need to understand is that insurance companies can't force you to go back to work. If your doctor or your therapist, whoever is treating you, is telling you you're not well enough to go back to work, and you feel that you're not well enough to go back to work, that's the message you give the insurance company. They can't come to your home and force you to go. Now, what they can do potentially is cut you off disability. But if that happens, or even if you have an inkling that it's going to happen, again, you immediately contact us because we can then guide you and tell you what it is you can do to avoid either being cut off, or if you get cut off, how to fight back. Because that's a secret out. There's a misconception out there that insurance companies can do whatever they want. They can't do whatever they want, just like employers can't do whatever they want. They are governed by certain laws, but they assume that people out there don't know what the laws are, and we can enforce those laws. We can enforce those rights that people have against insurance companies and hit them back and make sure they pay individuals what they are owed by law.
They start a claim with you. all right, I'm talking about the people that have this problem, they start a claim with you. One of all the wonderful benefits of that, I think one of the biggest things that to highlight is the fact that once they get you involved, the phone calls and the harassment from the insurance company will stop.
You know, John, you said it's a highlight, and it's true, it is a highlight. I have people that I speak with daily who, when I tell them, here's what you can get from the insurance company, here's what we can make them pay you, one thing they really hear is not even about the money, it's about the fact that they don't have to deal with the insurance company anymore. They don't have to deal with the adjuster, no calls, no letters, no emails. We deal with the adjusters, we push back. And that's very, very important to understand, because you're talking about people in their most vulnerable state. People who are either suffering from a mental health issue, a physical issue, or a combination thereof. It's extremely important for them to understand that once we are in their corner, hence the name of the show, they don't have to deal with that. They deal with us. We are now that wall, and we push back.
Another resource, this has to do with your show, In Your Corner, Savan, is mydisabilityquestions.com. Again, you can go there. It's a good resource. Ask your questions. A member of Savan's team or Savan himself will answer that if it has not been asked and answered in detail already. I'll give you one. For again, mydisabilityquestions.com. Says almost 2 years ago, I submitted a long-term disability application. The insurance company says that the application was denied, all right, denied due to poor medical documentation. I appealed twice, the old appeal, and was unsuccessful each time. There's a big shock. Am I out of options?
No, you are not out of options. So first of all, the biggest, again, one of the biggest misconceptions out there is that when the insurance company cuts you off or tells you that they're going to cut you off and then invite you to appeal, that little paragraph is always in every letter they sent you. We invite you to appeal the decision, that you think that you have to do that, that you have that, you know, you have the 30 days that they give you to appeal. Much like in employment law cases, that deadline means absolutely nothing. Your rights do not expire after 30 days. And more to the point, if you appeal the process, you're asking the same people who have cut you off in the first place, pretty please, can you reverse your position? They're not going to do that.
Right.
In the vast majority of instances, all that happens is that the situation delays itself. People are, for a longer period of time, without money. Avoid all that. How do we deal with it? We start a legal claim. We take the power out of the insurance company's hands. We, again, take the fight for them using the law, because that's what they understand. And John, understand this as well, that as soon as we start a legal claim, internally within the insurance company, they now have to deal with it in a different way. Their job now becomes to try and shut down this claim, because they're now bleeding money because they have to defend the legal claim.
Right.
So don't make that mistake. And also something very important to understand, you only have 2 years from the date of first denial to start a claim. So if you are in a position where you are getting towards the end of that 2-year period, you have to be very careful. If you pass that deadline, you may be extinguishing your rights to get the money you're owed under law.
Will they ask you to appeal just once?
No, they'll ask you once, twice, 3 times. I have people coming to me after 2, 3, even more appeals. And you know, the irony there is that had they come to me at the beginning, we would have already resolved their case. So sometimes they'll come to me a 1.5 years later after 2 or 3 appeals. We could have resolved their claim potentially in 6 months or even less. And that, again, that's what insurance companies want you to do. They want you to get frustrated so that you walk away from the money that's owed to you.
Because you would have tried. You would have said, I went through this process, I appealed, I guess I have nothing else I could do. They told me I can appeal, I did. I've exhausted all my options, because they don't tell you, by the way, there's also the ability to take legal action to resolve it. They say your option is to appeal. You do it, you aren't successful, and you think, I guess I'm out of luck, I guess I don't get disability anymore. And that's not the case. That process is a waste of time. It's intended to try to frustrate, as Savan said, so that you walk away. Don't let that happen.
I'll ask you this quickly before we go then. You mentioned the clock starts ticking at you have 2 years. Once I appeal, does it reset the clock though?
No, it does not. The 2
that's
years starts from the beginning. But remember, John, if you are cut off LTD, you are usually told you're going to be cut off in the future. It's not a past event. So if you are told, if you get a letter that says you're going to get cut off in a month, 2 months, 3 months, 4 months, start something now. Call us now, because maybe we can avert that cutoff. Maybe we can create a situation where you are not without any money for any period of time.
As far as Savan is concerned, and Lior, it's employmenthourtv.ca. The list of all the radio shows you can find on podcast or otherwise will be there. And do not forget, anytime, severancepaycalculator.com. We can't stress this enough, Lior, how important this tool is to find out what you're really owed. Finally, 1-855-821-5900 to reach out to Lior and the rest of the team. Guys, good for another week. It's been the Employment Hour in 30. We'll catch you again.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.
Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact. Over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first.